This is the Know Your Law series by Barefoot Law, a non-profit organization which uses digital innovation and technology to provide free legal information and guidance for all. For more information, visit www.barefootlaw.org.
Welcome to this webinar. Thank you, Rhoda, thank you, Rebecca and Sandra, for being part of this session. We're just going to discuss and understand how succession works here in Uganda. I'm going to hand over the microphone to Sandra Cheng. She'll be sharing on the dynamics of an illegitimate, the illegitimate child and out of wedlock, that part, as well as that section 2 and then section 15. So Sandra, take it away to Rhoda. So Rhoda, letters of administration and the dynamics of interests and powers within a marriage. Yes.
Under the amendment, there were two sections. I'm going to touch on one with regards to the letters of administration, the validity period of the letters of administration, as well as the letters of probate, because I think they're very similar. What the amendment does is it creates an addition, two additional subsections in each section that provide for one, a validity period for the letters, as well as granting court discretion to extend that period. So what that means is now once from the date of issue, the letters of administration and also the letters of probate are going to be valid for a period of 3 years. And also court can deem, if necessary, to extend that period. And so I think this is important because it means that it kind of provides for the administrators and the executors an ample period of time to be able to execute and operationalize these letters, because so many a times, despite court issuing letters of administration, there's still very many conflicts and wrangles that still come up, and I think what this extra period means is that these issues can then be resolved. Make sure that these issues are resolved to the benefit and protection of the beneficiaries of the deceased estate. Obviously, at least for me, I see this as the slight downside is that it does mean, or it can mean, a kind of an extension or a prolonging of these issues. Like, I think it leaves kind of, it provides a leeway or space in which beneficiaries' rights, especially historically, because of the society we live in, women, it means that some of these issues can then end up being prolonged and to the detriment of the beneficiaries. And also the fact that it would kind of draw out, and it can be costly as well, obviously, for the beneficiaries, because this means time, this means loss of maybe financial incomes during this period of trying to resolve the family squabble. So, but it is good that it means that there is a longer period within which the executors are able to make sure that they appropriately distribute the deceased property. The second section that I can present on was the repealing of section 3. So repealing means that so that section in its entirety, which is what the amendment provides for, will no longer be in effect. It will no longer be in force. It is invalid. It ceases to have any legal effect. And what this section was about was essentially any interest and powers that one can acquire during marriage. What the section provided for before was that there will be no interest or any powers that are acquired or lost by virtue of marriage. And so the provision actually provided that no one shall by marriage acquire any interest in the property of the person who he or she marries, or become incapable of doing any act in respect to his or her own property, which he or she could have done if unmarried. And of course, this in its current form, this obviously meant that it didn't provide for exceptions where one does acquire interest in property by virtue of marriage, and the rights that come about as a result of it. So, for example, provisions in relation to family land and property interest that's created by marriage under the Land Act, and this includes obviously, like, for example, spousal consent under the Land Act, which means that, for example, no transactions can be made in relation to family land without spousal consent. And so this section was in contradiction to that provision, and obviously the spirit of Articles 21, I think, which is against discrimination, and also Article 33 of the Constitution in relation to the rights of women. And so, because most of the time what happens is it is women that bear the brunt and or are mostly affected by these kinds of provisions, especially in relation to acquiring interest to property. So, for example, you can be faced with a situation where you enter into a marriage and you move into your husband's property, or property that is in his name, and so what this provision meant is that you essentially do not acquire any rights and can do nothing to your benefit in relation to any improvements or additions that you make to that property. And so it's important because now it means that women can exercise the rights that are accrued to them or are provided to them by the law under the different sections, both the Constitution and also the Land Act, and also the new provisions, which I think Rebecca and Sandra will touch on under the amendment. So I think it's a very, very good step in the right direction.
All right, thank you, Rhoda, for that. I'll come back to you with a couple of questions. I'm going to try Sandra once again. Are you ready for taking us through?
Yes, Daphne. Talking about the illegitimate child, first of all, I really want to thank Digital Human Rights Lab for supporting us to have this conversation today, as we all belong to the cyber law community of practice at the Digital Human Rights Lab. So talking about succession law is very crucial because it's very important of how we manage property. And you find that there's a lot of inequalities in the succession law, which really greatly affects women's life, their economically and socially. I'm not going to talk a lot about the law because I'm not a lawyer. Apologies for that, but we have Rhoda here and we have Rebecca, who are amazing lawyers, and they will share very many perspectives around the laws on succession. So the succession, as Rebecca has clearly also stated before, is not really, in most cases, they do not, is not largely used. In most cases, you find that they depend on the culture, the religion, and also the tradition to operate the matters of succession. And also, most times they also try to use the customary practices to determine the succession matters in our society as Uganda. Of course, with the Constitution of Uganda, it allows for the operation of the succession law, so long as it does not harm the rights of the marginalized groups, such as women and the children. But with that, you still find that customary practices that relates to the succession are very oppressive and discriminatory against women and children in regards to the Constitution of Uganda. So bringing into the discussion that we have about the illegitimate child, maybe I could just try to maybe define what illegitimate child means. So illegitimate child means an illegitimate child recognized or accepted by the disease as a child of his or her own. But also you find that some of the definition that has been obtained maybe from the Black Laws Dictionary defines the status, that's the status of a person who is born outside a lawful marriage and who is not later legitimated by the parents. So you find that legitimate children are those who are born outside the socially accepted confines of marriage based on our religion and based on our tradition in Uganda. So you find that the word illegitimate is very discriminatory in nature, and also, and yet in reality, there is no human being that should be described as illegitimate. When a child is born outside wedlock, and it should not be even though is born maybe under like rape, or they are born when both parents are not married, they should not be referred to as illegitimate, because they have a right as human beings to be proper children. So you find that as Rebecca and also Rebecca and Daphne has also clearly stated this, you find that the succession ordinance that started in the 1906 was discriminatory against the illegitimate children and the relatives in the succession matters, and by its recognition and also the preference to the illegitimate children and the relatives. So with this, it is very impractical in the light of the social and economic realities on the ground in Uganda, because when you, most of the times, the illegitimate children, you find that they identify them with another level in the society, and also they are being abused, and the abuse is only associated maybe most times to women, because maybe it's the women who have given birth to them, and also based on the tradition in the society. So you find that they're even being abused, like, you are stupid like your mother. And you find that these children, it goes along the way that the society even tend to predict the future of these children. And they are not just accepted, also maybe in case, mostly when it's the woman who has remarried, they are seen as a cause of conflict in the homes, and also they suffer a lot of rejection, both at home, even at school, because of the stigma that has been attached to them being illegitimate in the Ugandan society. So you find that with time, these children tend to develop a lot of inferiority complex from the constant criticisms of themselves and their mother by their relatives, and even the step family. So it tends to also affect their performance at school. And in most cases, they may not have the same rights as the official children in terms of inheriting wealth from their parents. And they grow up feeling a lot of stigma in their society, especially when they're constantly reminded that they are born out of wedlock. So in reality, there's really no difference between the legitimate and the illegitimate child when it comes to property distribution after one's death. So that means that all children are equal, whether born in or outside wedlock, and therefore they should have equal property rights. And that's why now that is what Rebecca talked about the repeal of the law. They're trying to reveal the definition of the legitimate and illegitimate children. And there will no longer be no illegitimate child or children in the homes, because now the new law will recognize them as children of the disease. So this, of course, will include children that are born outside the wedlock, also the adopted children, and also based on the law that is going to be repealed, they also partake around 75% of the share of the property when their father dies. So that is a bit about the illegitimate children or the word illegitimate. But I would also like to hear from the participants and also our lawyers here to share their perspective of what they think about the term. It would be interesting to hear a conversation around that. Yeah. Daphne, over to you.
I'm going to now hand over to Rebecca to just take us through section 27 to just elaborate and highlight what you feel would be crucial for our participants to understand more of. Yes.
So section 27 is a section 27 as is right now in our Succession Act that's still in force, but it's presented as clause 14 in the Succession Amendment Act of 2021. Basically deals with the distribution of property on death of an intestate. Like Rhoda mentioned earlier on, an intestate is someone that dies without leaving behind a valid will. So this particular section, I think, became a section of contention in firstly the case of Law Uganda versus the Attorney General, where it was cited for being discriminatory on the basis of on grounds of being discriminatory on grounds of sex. Basically, the section provided for distribution of property of a male intestate. So one of the arguments that the lawyers presented was that, does this imply that women do not own property on their own or have no property that can be distributed on their death, upon their death? Or how do they proceed? How is court guided when distributing property of a female intestate? So on those particular grounds, the AG conceded, and then it was declared, that particular section was declared null and void. Like I mentioned earlier, this left a gap for courts, the magistrates courts and high court, on how to distribute this particular property of an intestate, because then each case was really determined on its own facts, which one could argue was a bit equitable because no one family is the same. But at the same time, there needed to be some form of guidance for courts on what to rely on, what basis are you using to distribute this percentage to a particular group of beneficiaries, as opposed to what was done in the case before or what will be done in the case after that one. So that is why it was prudent for us to amend that particular section. In the law as is right now, it provides that spouses get 15%, the surviving wife, if we're to be very specific, gets 15%, the lineal descendants, who are the children of the deceased, regardless of whether they are legitimate or illegitimate children. Although that term also was declared null and void in that case, unconstitutional for being on grounds of being derogatory. So those would get 75%. Then we had the dependent relatives getting, the customary heir getting 1%, and the dependent relatives getting the rest. So initially in the private members bill, it was proposed the spouse receives 50%, the lineal descendants get 41%, and then the dependent relatives receive 9%. We had proposed that the customary heir is completely eliminated because from what we had various discussions with various stakeholders had indicated that customary heirs, one, were usually children to the deceased, so they would therefore be benefiting as children or lineal descendants already, but then also having this additional percentage granted to them was likely to get to their heads, and there was usually abuse of this of powers, and we had so many instances of customary heirs thinking that they were taking on the position or the place of the deceased in regard to property, and usually this ended up what happened was that widows, who were usually the victims, also were chased out of the principal residential holding because they assumed now that they are customary heirs, they have been appointed customary heirs, they take on the position and place of the deceased, and yet really for most cultures this position is merely ceremonial. So that was what was initially reflected in the Private Members Bill. Subsequently, after discussions with the government side and further consultation, what is reflected now in the bill, the Act, the Succession Amendment Act of 2021, is that this was a government proposal that we thought was very good, and it presents its own challenge, and sometimes really this may call for liquidation of an estate in order to be able to quantify this 20%. But really what they provide for, one thing that is really commended and is now reflected within our Act now, although the Act does not have force of law yet, is that 20% of the estate shall not be distributed. So it is reserved and held in trust for the education, maintenance, and welfare of certain categories of lineal descendants. Those are children, until they cease to qualify as such. So one is a child of an intestate. You'll notice now that they use the word a child. That's basically to refer to lineal descendants who are below the age of 18 years. So those children will be taken care of, school fees will be paid, ordinary necessaries of life will be provided for until they reach the age of 18. That's category 1. Category 2, we have lineal descendants. These are basically all children, regardless of age, of the deceased who are above 18 years, but below 25 years of age, but are still undertaking school and are not married. So for many children after 18, you're just probably joining university, and you don't have your life figured out as a young adult. So it's prudent that the estate still provides for your education, at least food, shelter, things like that, until you're you either attain the age of 25 or you marry. At which age, if you're marrying, we assume that now you're in position to look after yourself and your new family, or a lineal descendant of the intestate who has a disability. If at the time of the death of the intestate, they were not married, or they were not married and were wholly dependent on the intestate for his or her livelihood. These also were a category of beneficiaries who tended to be disenfranchised the most, because then after property has been distributed, who's going to look after them? Their needs are far greater than children who are able-bodied and are in position to look after themselves. So these they were dependent wholly on the deceased to be able to survive. So it's necessary that their life is not disrupted so much. Granted, it will be disrupted, but there is some form of continuity that needs to be put in place. Then they also propose that if an estate produces periodic income, for example, probably the estate has a running business, has any form of income that's coming in, probably from rentals or, like I mentioned, a business, that particular percentage can be calculated from that business and reserved for the maintenance of those particular categories of people. When it came to the distribution or percentages that are given to particular groups, the surviving spouse, both widow and widower, will receive 20%. The dependent relatives receive 4%. The lineal descendant, those are the children, both legitimate and illegitimate, that distinction has been done away with, will receive 75%. And the customary heir was reintroduced. The argument here made was that customary heirs are still a very integral part of our societies and cultures, and we need to recognize them as such. Will receive still 1%. Largely from our consultations that we had, so many people, men and women, were not willing to concede to having their surviving significant other receive 50%. Although the argument that we had made was that the law provides, I think in Article 31, that both a man and wife are equal at the start, during, and at dissolution of a marriage. So that means death, which is one of the factors that dissolves a marriage, should also mean that the spouse should be equally entitled to their deceased spouse's estate. So largely this was rejected. And then also the government, one of the arguments that government gave was that for most estates, well, you have an average of 6 children in the household. So if you give the largest proportion of the estate to the spouse, you're disenfranchising the children, who would then have a less portion compared to the spouse. So yeah, so we considered and we said yes, it actually makes sense for the children to receive the largest portion. And then also through consultations all over, it was recognized that in fact children should get the largest proportion, and people were not comfortable with their spouses, surviving spouses, getting the large proportion. So it goes on and keeps eliminating particular categories. For example, it says here, where someone dies, let's just say someone, and leaves behind no surviving spouse or dependent relative, but leaves behind children. So this particular individual was neither married or had no dependent relatives. That does not necessarily mean that they have no relatives. Dependent relatives, there's a test of dependency. You are wholly and substantially dependent on the deceased for ordinary necessaries of life. So basically that could be probably an old and ailing parent, that could be probably a niece or nephew that you've taken on, but not legally adopted, people of that category. So if you have neither of those, the proportion of your estate that those would take, that is the spouse taking 20% and the dependent relatives 4%, will be added to the 75% that your children would get. So in essence, they would get 99% of the estate, and 1% would go to the customary heir. Then the third category is where the deceased person is survived by a spouse and a dependent relative but has no child. The spouse receives 80% and the dependent relative shall receive 20% of the whole of the estate. This is one of those provisions that in his response paper, the president had challenged and asked for the parliament to review. I guess we'll get to that later. But he presented arguments. Then where the intestate is survived by a spouse and a dependent relative but has no children. So you either have a spouse or a dependent relative. The spouse or dependent relative, as the case may be, shall receive 100% so of the whole estate. And then E, where the intestate or deceased person leaves no one surviving them capable of taking, no one under those categories that we have mentioned. You neither have a surviving spouse, neither do you have a dependent relative, neither do you have a linear descendant or customary heir capable of taking your property, taking on that property. It shall be divided equally between the relatives nearest in kinship to the intestate. So your siblings, your parents, if they were not dependent on you, probably your uncles and aunties, your cousins. So they'll look at that is where the degree of kinship comes in to determine who else can benefit from this estate. So where you also have no kinsmen, the whole of your property shall be managed by the Administrator General in accordance with the Administrator General's Act. So I think basically that is those are the new proposals under Clause 14, which is still Section 27 of the Act. Yeah, so I think also it's prudent to mention that the principal residential home and the other residential home, which are both defined within this law, are reserved from distribution. So in addition to reserving the 20%, if you have lineal descendants that fall within those categories that I mentioned earlier on, they will reserve the principal and other residential properties for the benefit of both the surviving spouse and the lineal descendants. So what that basically means is the amendment that was made was that now currently as is, the principal residential home is held in trust by the surviving spouse and children. It's held in trust for the legal heir. So for example, it could be a son. So that was really unfair, because essentially that means that the surviving spouse and children just have occupational rights. That's why you see in the second schedule to the Act right now, we had specific guidelines of how these particular categories of people would occupy until the age of 25 for girls, until the age of 18 for boys. That alone is discriminatory. Or for a surviving spouse until you remarry, because you're only occupants of this house, but the reversionary interest in the property was for the legal heir. So that was changed, and now it's reserved for the benefit of both the surviving spouse and the lineal descendants. And the way in which they own this property is joint tenancy. So you cannot particularly mention that one person has more control over the other. So this was also a way to preserve that particular estate for the benefit of both the surviving spouse and the children. I don't know if I can mention anything else. Yeah, I think that's all I can talk about when it comes to distribution of property of an intestate rather. Thank you.
Thank you, Rebecca. That's very, very detailed.